It's quite possible for the people to abolish the death penalty, to permit homosexual conduct, or for that matter, same-sex marriage, and to permit suicide and all sorts of things. The issue is whether a judge can say the living Constitution has morphed, and so what used to be okay is now not bad, is now bad. That's the living Constitution I'm talking about, and it's the one that I wish would die.
The words in the example in the Constitution are cruel and unusual. Those are the words. It doesn't talk about the death penalty. It's embodying certain values. Now, we were making a little more progress at the beginning of this, when you could see this,
You have a lot more hope for this thing than I do.
But the reason I find it complicated and difficult is this kind of a question is maybe the metaphor that's helpful to me after a certain period of time, and I think after a member of our court for a certain period of time, and it does take time, I think you develop a kind of view of the Constitution because we have so many constitutional cases. And you begin to say, what is this document about, really? And I think most of us, and I know that many of my colleagues agree, and I'd be surprised if you didn't. If you want us to really oversimplify and say, what is it? This is a document that creates institutions of government of a democratic kind. I agree with that, you see. But the heart of this Constitution is democracy. And that means that people, through their elected representatives, decide for themselves what kind of laws, rules, administrative regulations, all kinds of other things they want governing themselves in their cities, towns, and states and nation. It's their decision. At the same time, it creates a certain kind of a democracy. And that's a democracy that protects basic human rights, assures a degree of equality, divides power, state, federal, in 3 branches so no one becomes too powerful, and insists upon a rule of law. Now, having said that in general terms, I think you see our job as a job of not interfering with democracy, correct, but a job of guarding the boundaries, because there are boundaries in that kind of Constitution that gives tremendous leeway to the legislature, but still that legislature cannot go too far. It cannot exceed the boundary. And we're there, in a sense, like a boundary patrol. Now, some of those questions on the boundaries are pretty difficult. And you've mentioned a few, and I might stay away from too many specifics. But those questions are difficult, and they often divide us. But what doesn't divide us is the fact that the job of a court is still at the boundary. And our job primarily is to preserve that democratic process. I think you'll get 9 votes for that one. And of course, that's why I'm glad you're here, because you're participating in that process, etc. And I've written about it and believe it's important. But it's important to keep in mind that while we disagree at that boundary, it isn't necessarily because we think the democratic process isn't important or is important. The question is how you interpret those difficult words, and I'd begin to repeat myself, so I'll stop.
But why should unelected judges be able to invalidate laws that don't conflict with the text of the Constitution?
Oh. Well, where is an example where they don't conflict with the text? I've never heard of somebody say not conflict with the text. The question is the word.
Try Roe versus Wade, just for starters.
Thank you. In any of the opinions, of course, you have words of the Constitution, like the 14th Amendment word liberty, or the First Amendment's word the freedom of speech, which don't explain themselves very often in difficult cases. So then I say life at the boundary is sometimes tough. It's like I keep thinking of the Frontier Patrol or something, because it doesn't explain itself. It's a hard question, and you have to have tools to answer it. And you put your mind to it, but the bottom line, if it's unconstitutional, is going to be that it's forbidden by this word or that word or phrase or this part of the Constitution. And there is no doubt about that. And
it's easy to find those phrases: equal protection of the laws, due process of law. Those phrases are empty bottles if you accept the proposition that each generation can fill them up with whatever liquid it wishes. Now, I too believe in democracy, and I think the way it works is this: the majority rules. If you don't believe in that, you don't believe in democracy. Now, in a liberal democracy, which is what we have, there are some things on which the majority does not rule. That's what our Bill of Rights is about. The majority will not rule on religion. It will not rule on limiting political speech or any other speech, and so forth. Unreasonable searches and seizures, the whole list. That's mostly what the Bill of Rights is about. Limitations on the majority, which are applied through the judges. Okay. Who decided upon those limitations, however? The majority. It was the majority itself that imposed those limitations in adopting the Bill of Rights. And whenever the judges go beyond the meaning understood by the society that voted for those limitations, whenever it goes beyond that original meaning, it is in effect adding to those subjects that are driven off the democratic stage. Now, there was nobody who ever thought that due process of law meant that abortion could not be prohibited. It was prohibited for 200 years. Nobody thought it was unconstitutional. Again, I'm not talking about whether it's a good or bad idea. The question is, who decides? If you interpret a Bill of Rights so that judges can decide, oh yes, we have this empty bottle here, it's called due process of law. And we're going to say that it's a procedural guarantee, to be sure, but we're going to say that some liberties are so important that no process will suffice to take them away. Which liberties are they? We will tell you. Nobody would have voted for a constitution that said that the meaning of equal protection of the laws, whether it means there has to be same-sex marriage, for example, is to be as determined in the future by the Supreme Court from year to year. Nobody would have voted for a constitution like that. And the only way to retain the democratic process is to recognize that the Constitution has an amendment clause. And those things that the people didn't agree to, such as same-sex marriage, nobody ever thought it's covered by the Equal Protection Clause or anything else. If you want it to be covered, amend the Constitution. Or, for that matter, if you want to do it at the state level, you don't even have to amend the Constitution. Just pass a law. That is an interpretation that gives effect to democracy. But to allow judges to use these broad phrases, to give them whatever meaning seems sensible today, even though it did not seem sensible to the people who adopted the Bill of Rights, that to me is quite anti-democratic.
Justice Breyer.
At the risk of making this very interesting discussion a little less interesting, I would guess, and others can know, that if you look at the different parts of the Constitution, and there are quite a few words, not that many, it's brief, succinct, and very, very valuable to this country. You'll find a lot of phrases, a lot of words, and we frequently measure against those words laws passed by Congress or state legislatures to see if they exceed the boundaries that those words set. I suspect that if you look across 10 years' worth of cases, you will discover that between Justice Scalia and myself, really the number of times that words say they are exceeded, unconstitutional, or not exceeded, there isn't much difference. And you can't say one person is more willing to strike down laws passed by Congress than another, at least if you look at what actually happens in the court.